again, and welcome to this Office of Open Government FOIA training. This is the third in the FY 2026 series. And the title today is Commonly Used DC FOIA Exemptions and Redaction. My name is Joan Lelma. I'm one of the two FOIA I am one of the two attorney advisors in the Office of Open Government. I guess I've been thinking about FOIA a lot. And the office is led by Director Nicole Allen. Chief Counsel is Lois Neal. The other attorney advisor is Anthony J. Skirbo. He's also the FOIA officer for BEGA, Board of Ethics and Government Accountability. And there are two offices within BEGA, OOG, the Office of Open Government, and OGE, Office of Government Ethics. Paralegal specialist is Kimberly Brown. We also have our child attorney, Brandon Lois, and our IT specialist, Kevin Brown. Kevin serves both offices, OOG and OGE. If you have questions, please place them in the chat and one of my colleagues will respond while I'm presenting, or if you'd like to hold them until the end of my presentation, I will respond to your questions at that time. Also, this training material will be available at open-dc.gov after the training. This is our course outline. We will first discuss the FY 2025 FOIA report, and then we will examine the most frequently used of DC FOIA exemptions, which are exemptions 1, 2, 3, and 4. And then we will complete or close out this training with redaction. And so since we'll be speaking a lot about exemptions for those who are new to FOIA, exemption means that certain records or information held by government agencies are not required to be disclosed to the public, even when an appropriate or complete FOIA request has been submitted. And the exemptions are codified at DC Official Code, Section 2-534. Commonly used exemptions and the report that concerns the agencies, or determination and examination of the most commonly used DC FOIA exemptions are based on the mayor's fiscal year 2025 FOIA report submitted to the DC Council. The same exemptions as in FY 24 prevail as the most commonly used, but of course there are changes in numbers, as we will see moving along, and slight shift in terms of the frequency of application. Exemptions 1 and 4 have traded places. So trade secrets has traded place with agency communication exemption 1 and 4 respectively. And we see that exemption 2, personal privacy, still holds its position as the most frequently used, followed by law enforcement exemption 3, and the subcategory C of exemption 3 still holds position, that is personal privacy. And then, of course, as we have said, trade secrets, followed by agency communication. DC Official Code Section 2-538A provides for the mayor providing this report or submitting it to the DC Council, covering record disclosure activities of each public body during the preceding fiscal year. And we will cover the total FOIA requests in FY 2025. The exemptions used over 200 times, and the agencies with the highest request. So when we look at 2023, 2024, we see a steady increase up to FY 2025. And so it's 13,923 for FY 2025, increasing from 12,260. And the annual report is available at the Office of the Secretary's website, and the link is here. Agencies with the highest number of requests. So where I've put an I in brackets and a D, I shows that there has been an increase, and D signifies a decrease. So you may notice that I have 3 of them in red, and that's because these are the highest agencies with the highest number of requests: Department of Buildings, 1,253, FEMS, 1,575, and MPD with the highest, 3,678. Now you may notice also that I have not put an I or a D beside Office of Unified Communications, OUC. That's because OUC was not on this list for FY 2024 because it has a significant increase, has made the list coming from 69 to 396. So let us move along here and examine now the most frequently used exemptions. As we looked at earlier, trade secrets as switched or traded places with agency communication, which is exemption 4 at 301, and trade secrets 373. Exemption 2, personal privacy, 2,399, the highest. And then we have law enforcement, 1,531. And as we examined earlier, that subcategory C has the largest amount of frequently used exemptions. Records that constitute an unwarranted invasion of personal privacy. The description of the exemptions. Exemption 1 protects trade secrets and commercial or financial information obtained from outside the government, and disclosure would result in substantial harm to the person's competitive position. And as we look at the federal side, where DC FOIA relies on federal FOIA, we will get into the portion of confidentiality, what it means, because the exemption equivalent under federal FOIA exemption 4 addresses that aspect. The cases that apply or look into exemption 4 also determines what is confidential. Exemption 2 protects information about individuals where the disclosure would constitute a clearly unwarranted invasion of personal privacy. If you notice that I have clearly highlighted in red, because that's a higher standard than exemption 3. And so as we move along too, we'll see cases where a freedom of press case where Justice Stevens made the distinction on the federal side between 7C and exemption B6, where one requires one has a higher standard than the other. And it's the same as it relates to DC FOIA exemption 2. Exemption 3 protects certain investigatory records compiled for law enforcement purposes, including records of counsel investigations, and the Office of Police Complaints. And so the arm of Exemption 3 that we are comparing with is 6 and 7 in terms of higher standard, it would be the subcategory C. Exemption 4 protects interagency and intra-agency deliberative and pre-decisional materials written as part of the decision-making process in DC agencies. So interagency, between agencies, intra-agency, within agency, and then when we look further at the cases and what is deliberative, what is pre-decisional, we will see that they have two arms, so Exemption 4, it's really exciting to get into it. I know sometimes it seems daunting and even intimidating to some, but as we go through today, I hope that you will get excited about applying these exemptions correctly, including Exemption 4. Application of federal FOIA to DC FOIA. DC FOIA was modeled on the corresponding federal Freedom of Information Act, and this was stated in Barry against Washington Post. The court states that the District of Columbia FOIA was modeled on the corresponding federal statute, and many of its provisions closely parallel those of the federal act. And like federal FOIA, the local FOIA embodies a strong policy favoring disclosure of information about governmental affairs. And so this takes us to the statement of policy in the statute, so that disclosure is favored. And so we have to be careful how we apply these exemptions. Yes, they're there to safeguard certain information, but they must be applied correctly. And so this is also used, it's a language in Washington Post against Minority Business Opportunity Commission. So they use the federal FOIA statute to construe the local law, DC FOIA. Trade secrets, Exemption 1. So this agency must show that the information is a trade secret, commercial or financial information, was obtained from outside the government, and would result in substantial harm to the competitive position of the person from whom the information was obtained. And so as we talk about this prong 2 was obtained from outside the government, as we move along, we'll see on the federal side the different elements for determining such. And so protection of proprietary interest from public disclosure. In Public Citizen Research Group against FDA, the Circuit Court has defined trade secret for the purposes of federal FOIA as a secret, commercially valuable plan, formula, process, or device that is used for making, preparing, compounding, or processing of trade commodities that can be said to be the end product of either innovation or substantial effort. The DC Circuit has also instructed that the terms commercial and financial use in federal FOIA should be given their ordinary meanings. Exemption 1 has been interpreted to require both a showing of actual competition and a likelihood of substantial competitive harm. And the case on point here is CNA Financial against Donovan. Exemption 4 on the federal side, trade secrets or commercial or financial information that is confidential or privileged. And so this is the arm that I spoke about earlier. What is confidential? Let us see the different steps. The landmark case, well-known case, Food Marketing Institute against Argos, a leader, Supreme Court 2019 case, where the court held that information is confidential and protected if one, the information is customarily kept private or at least closely held, and two, where the receiving party provides some assurance that the information will remain secret. And so there are different aspects to this questions to be asked. The first is, does the submitter customarily keep the information private or closely held? And if your answer is no, then it's not confidential. However, if it is yes, you have to move on and make more determinations. You ask the question, did the government provide an express or implied assurance of confidentiality when the information was shared with the government? And as we move along, you will see that implied assurance can constitute confidentiality. If your answer is no, answer question 3. If your answer is yes, the information is confidential. So let us move on to question 3, where we see the implied portion. Were there express or implied indications at the time the information was submitted that the government would publicly disclose the information? If your answer is no, the information is confidential. If the government is silent, the submitter's routine practice will be sufficient to determine that the information is confidential. However, if your answer is yes and no other countervailing factors exist, a submitter cannot expect the information to be confidential. And so where there were indications that it would not be held confidential, the submitter cannot go back on what has been agreed upon. And this test question and answer segment is available at DOJ's website. The link is here. And so let us get to personal privacy exemption 2. And this is information of personal nature where the public disclosure would constitute a clearly unwarranted invasion of personal privacy. So higher standard than 3C or a B7C as it relates to 6 on the federal side. And so in Hines and Board of Parole, the DC FOIA exempts the release of pre-sentence reports, academic records, mental health assessments, and other records pertaining to prison inmates' applications for minimum sentence reductions. In the Fraternal Order of Police case, the 2015 case that applies the earlier Fraternal Order of Police case, they both look to the U.S. Department of Defense case, which is a federal court of appeal case, for the court to have determined in the 2015 case that DC FOIA exempts personal information of public employees unless the requester shows that the information withheld will shed light on an agency's performance of its statutory duties or otherwise let citizens know what the government is up to. And so if it is solely personal reasons or benefit, it will not shed light on the what the agency is doing, what the government is up to, and that's where the balancing test now comes in. Then we know that the exemption, we know that the test, it's outweighed. Then, as in DC Court of Appeals 2015 case, balance the privacy interests of individuals with the public interest in disclosure and found that the private interest was not outweighed by any public interest identified by the FOP, because its intended use of the information was to educate police officers and defend those facing disciplinary action. And that was a private interest. So it was not benefiting the public. So let us move along here with our balancing test. Privacy, as we spoke about earlier, the exemption 2 on DC side and exemption 6 on the federal side, that they have a higher standard than their corresponding 3C and B7C. However, unlike the language of the federal statute, which limits its comparable exemption to personnel, medical, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of privacy, DC FOIA exempts all information of a personal nature. And so it seems as though exemption 2 is broader. However, in the Supreme Court, U.S. Department of State and Washington Post, the court held that based on the legislative history of FOIA, Congress intended for the term similar files to be interpreted broadly. So the court stated that the protection of the individual's privacy surely was not intended to turn upon the label of the file which contains the damaging information. Rather, the court stated that the information applies to a particular individual, which meets the threshold requirement of exemption 6 protection. However, the court found that it must be linked to a particular individual. For if it is not so linked, then one would look to 7C and to determine whether that applies. And so let us continue on with our balancing test. The landmark case, Department of Justice against Reporters Committee for Freedom of Press, when determining whether the exemption for personal privacy would apply to requested records, both DC, FOIA, and federal apply this standard, which requires that the government balance the individual's privacy interests against the public's interest in disclosure. A FOIA officer must perform the balancing test under this exemption. The individual's privacy interests in the material at issue must be balanced against the public's interest in disclosing it. And this public interest, the court states, must serve the core purpose of shedding light on an agency's performance of its statutory duties. So when we lend our minds to the Fraternal Order of Police case, that was not going to shed light on the agency's performance. They require that information for disciplinary matters as it relates to the FOP. And so there was no shedding of light per se, and for the public to benefit greatly, or for such benefit to supersede the privacy interests of those involved. And so let us move along here to an advisory opinion that Director Allen issued, and it's available at open-dc.gov under the Documents and Training tab, where the director provides the steps of balancing, the steps for going through this balancing test. And so the first is the initial question, whether there is more than a de minimis privacy interest in the records that are subject to the FOIA request. Absent more than a de minimis privacy interest, the underlying principles of FOIA would require disclosure of the records. If it's established that the individuals maintain more than a de minimis minute privacy interest in the records, the next question is whether there is a public interest in disclosure that outweighs the privacy interest. And then to establish a FOIA public interest in disclosure, the information sought must serve the basic purpose of the FOIA to open agency action to the light of public scrutiny. And when privacy interests are implicated, the burden is on the requester to establish that disclosure would serve a significant public interest and that interest must be more specific than having the information for one's own sake. We then lend our minds again to that fraternal order police case where the requirement for the use of that information was so contained, it was personal to that group or organization. And then when we address, we'll see how other cases are addressed as we move along on the other side. So if the information is for the requester's own sake, the privacy interest is not outweighed by the public's interest. And these are some more examples of the balancing test in this matter, Washington Post. The privacy interests of students and teachers under investigation for the consumption of alcohol substantially outweighs the public interest in their identifying information. And in this matter, Walter Thomas, it was found that information may disclose the names and professional qualifications, work experiences of successful job applicants may be disclosed, but refuse to disclose other private information such as home, phone numbers, addresses, social security numbers, marital status, and personal references, or any information regarding unsuccessful job applicants. And that's self-explanatory. They are not government employees. And so providing their professional qualifications, work experiences will not shed any light on that government body. So that's the balancing test there. Let us move on to law enforcement. And so some of the prongs in law enforcement here are interference with investigation. So information may be exempt if there will be interference with investigation. Also right to fair trial and personal privacy. And I believe you know that one by now is the C prong. So the exemption allows non-disclosure when disclosure would interfere with enforcement proceedings or counsel investigations, deprive a person of fair trial, constitute an unwarranted invasion of personal privacy, disclose the identity of a confidential source, disclose investigation techniques, or endanger the lives or physical safety of law enforcement. I know that the exemption applies only to investigatory records that are complied in the course of specific investigations and that focus on specific individuals. Fraternal Order of Police case here, 2014. It was held that records concerning use of breathalyzer were exempt only if the documents requested were compiled for law enforcement purposes, and disclosure of those documents would interfere with enforcement proceedings. So moving along with law enforcement, while the threshold requirement for this exemption to apply is that the record or information sought must have been compiled for law enforcement purpose, there are some exemptions. I shouldn't say exemptions. There are a few exceptions where the courts have held that the law enforcement purpose encompasses a wide variety of records and information. And so records compiled as part of violence investigations or drug trafficking investigations include records pertaining to the use of informants have been found to meet the threshold. Also, records compiled as part of investigations into nonviolent illegal activity have been found to satisfy the threshold, as have records used in efforts to prevent wrongful activity. And so courts grant agencies wide latitude in defining law enforcement purposes, but they are still not allowed to depart from, the stated law enforcement, compiled for stated law enforcement purpose. So while they have wide latitude, this still applies. So when the records exist independently of the stated law enforcement purpose, then it doesn't apply. And when the associated investigation was conducted for an improper purpose. And there is a balance in the DC FOIA seeks to strike a balance for maximum disclosure, even of law enforcement information, but not in cases where the information would endanger people's lives. And so an example here is Glenn against MPD. The Mayor's Office of Legal Counsel, MOLC, ruled that investigatory records in a 6-year-old murder case are exempt from disclosure if charges and criminal litigation are still possibilities. And there is another matter here, Molly Parker. MOLC held that the privacy interests of police and crime victims' family militate against releasing a videotape murder confession that was never admitted into evidence against the accused when the tape was sought by a news reporter. And we'll see a common thread here also where the MOLC held that disclosing a police officer's records regarding an investigation into alleged drug abuse when no disciplinary charges were brought and absent allegations that the investigation was mishandled would serve no public purpose. So we see that balancing taking place. And let us move along here to look at exemption 3C, since this one has been used so often. So while exemption 2 requires that the invasion of privacy be clearly unwarranted, the word clearly is omitted from exemption 3, as we have examined before. Thus, the standard for evaluating a threatened invasion of privacy interests under exemption 3 is broader than under exemption 2. And likewise, the Supreme Court has interpreted the equivalent exemption, 7C. In this case, we mentioned earlier, Department of Justice and freedom of press, where Justice Stevens spoke to that one. And so as we have made this distinction and this higher burden, let us move on to see what is happening on the federal side as it relates to civil cases and B7C, as we are reminded that DC FOIA is modeled off federal FOIA, and DC FOIA looks to the federal side, looks to the cases as well coming out of those exemptions. So under federal FOIA, B7C has been applied in civil cases. And a case on point here is Safeguard Services against the SEC. The Court of Appeal agreed with the district court that the SEC had correctly applied B7C by deleting or redacting names and addresses of third parties mentioned in witness interviews of customers listed in stock transaction records obtained from investment companies and of persons in correspondence with the SEC. The court held that the public interest in disclosure is not just less substantial, it is insubstantial. And so it would be difficult for someone to do that balancing test and let it tip in the favor of disclosure, or, because obviously the privacy interest is so huge. And then it's not a de minimis privacy interest. When you even look on the benefit to the public, the court says its disclosure is not just less substantial, it is insubstantial. So there will be no benefit to the public. Law enforcement exemption 3C, determining whether disclosure of a record would constitute an invasion of personal privacy requires, as we have been talking about balancing of one's individual privacy interest against the public interest in disclosure. That's our case, safeguard. In putting forward this balancing test on appeal, the court cited the landmark Supreme Court case, the freedom of press case. And so you see the connection with the cases there, not overruling that landmark, but staying in line. However, we have a little history with some differences here and there. Absent substantial allegations of wrongdoing, courts generally recognize that law enforcement personnel have a privacy interest in non-disclosure of their names due to the potential for harassment or embarrassment if their identities are disclosed. And in this case, Abram against the US, the court states that clear privacy interests exist with respect to names, addresses, and other identifying information, even if it is already available in other public filings. And when we compare this case, you can, in your own time when going through these slides, compare it with a recent Maryland Court of Appeal case. In this case, the appellate court issued an opinion that the public access to public use of force records under the Maryland Public Information Act, as amended by Anton's law, the court held that the police use of force reports must be disclosed with the officers' names because they are not personal records and are created for factual reporting, not performance evaluation. It also ruled that use of force reviews are investigatory records covered by Anton's law and must be released, but only after required redactions are completed. And so you can, make the distinctions later on. And this is the portion that I was alluding to. I was getting ahead of myself when I mentioned about the history and the differences, how the cases moved about. Prior to reporters' committee and safeguard decisions, courts ordinarily held that because Exemption C involves a balancing of the private and public interest on a case-by-case basis, there existed no blanket exemption for the names of all law enforcement personnel in all documents. Nonetheless, absent a demonstration of significant misconduct on the part of law enforcement personnel or government officials, most courts have declared their identities exempt from disclosure under 7C. Those few decisions ordering disclosure of the names of government investigators other than when demonstrated misconduct has been involved or taken place either predate reporters committee or else the court found an unusually significant interest in disclosure. Note, though, that there are two Court of Appeal cases for the Ninth Circuit, which is about 10 years or so after Reporters Committee, that ignore the well-recognized privacy interests and refuse to adhere to the narrow definition set forth in the landmark case of Reporters Committee. And these two cases are here, Listener and Favish. So that's the little historical development part that I alluded to. And now we're at exciting agency communication, Exemption 4. All of these exemptions are great in going through and applying, but this has so many prongs. And once you get a hold of it, then you will be excited about applying them. So interagency or interagency memo or letters, it covers those documents. It incorporates civil discovery privileges or litigation privilege. And so let us move ahead here and get into It covers records that would not be available by law to a party other than a public body in litigation with a public body. And so it provides exemption from disclosure for privileges, which could be asserted in litigation, deliberative process privilege, and we'll see that they all have two prongs: attorney-client privilege, attorney work product. So DC FOIA, DC Official Code Section 2-534E expressly provides that the deliberative process privilege, the attorney work product privilege, and the attorney-client privilege are incorporated into Exemption 4. Case on point here is Kane. And historically, the MALC has used the common law deliberative process privilege to find that documents are exempt from disclosure under Exemption 4 because they would not be available to a party in litigation with the agency. In Alonzo Williams against the Office of Superintendent, the mayor's office relied on the common law deliberative process privilege to find that documents are exempt from disclosure. And so, so in this case, memorandum from a hearing examiner was withheld, whose recommendation was rejected by the superintendent of schools, the final arbiter of the decision at issue. And so when does the exemption applies? To fall under Exemption 4, as we have stated before, the record must be an interagency or interagency record, and there must be an applicable litigation or civil discovery privilege, deliberative process, attorney work product, or attorney-client. And these are the two elements or prongs we spoke about earlier. So for deliberative process privilege, it must be pre-decisional and deliberative. And then we'll see what is meant by pre-decisional. Pre-decisional communications precede the adoption of an agency policy. For the pre-decisional element to be found, the agency must be able to identify a decision-making process that led to the creation of the withheld document. And so if they're just documents that are looked at, there's no comments, no process of making a decision, then we know that the pre-decisional is not found there. And note that final agency decision is not required concerning federal FOIA. Courts have recognized that agencies sometimes decide not to decide, meaning there was a process, but the intended outcome or the end result was not achieved. But that does not take away from that process, that involvement, what was discussed, what was agreed upon before getting to that end result, before getting to that decision. So that decision was not arrived at, but there was a process, which still makes it pre-decisional, that they are pre-decisional records. What of post-decisional? These, of course, are not protected by the deliberative process privilege. And examples are documents that reflect an agency's final position on the issue. So it's not records of the process, but the final decision concerning a specific issue. The next post-decisional documents that explain an agency's actions, not documentation of the decision-making process, but explains why the agency has taken a certain position. The public has a right to know about the official action of agencies. And this goes back to the preamble of the statute, speaking of openness and transparency. And that is what the statute sets out to create that balance. And so the common thread in these two examples are post actions after the decision. Deliberative communications are offered in support of agencies' decision-making process. And so there are some words that can, point to you that, okay, there is deliberative process privilege here, such words as in my opinion, my recommendation. However, these are words to assist, but they are not an end in themselves to make such a determination, because there might be deliberative communications there and these words are not used. And so you must examine the records properly to make that determination. So moving along with agency communication. As a matter of policy, reports and analyses prepared by an organization outside the government, even if they are used in an agency's deliberative process, they do not fall within this exemption. And the case on point here is Belth. The court states that to hold otherwise would be to rule that the independently initiated, prepared, and funded reports of a private organization which that organization desires to withhold from public scrutiny and discussion, but to have used by a governmental agency as a basis for important public policy decision would be immunized from disclosure. And so outside, independently initiated, and it has public policy, important public policy decisions, that is not supposed to be withheld. It's not supposed to be fall under the exemption. And so we'll see, like all rules, there are exceptions. And the exception to this rule is the consultant corollary doctrine. And this extension of the, in some limited circumstances, a non-agency party may act as a consultant to the government, and in such cases, their communications may qualify as an intra-agency exchange for the purposes of Exemption 4. And these are some cases on consultant corollary doctrine. So consultants can be those who have a formal contractual paid relationship with the agency. And the case on point here is Hoover, as well as those consulted by the agency on an unpaid volunteer basis. Case on point is Wu against National Endowment for Humanities. And in Wu, a Chinese scholar of history, a scholar of Chinese history, who had previously filed an application for a grant from the Endowment for Humanities to write a history of the Chinese people, sought disclosure of the reports of the 5 outside experts who evaluated his proposal and recommended that it be rejected. And the court denied the disclosure request, holding that the experts' reports were intra-agency memoranda, even though the 5 professors were not actually agency employees. And so this demonstrates that the test is not whether it's a paid or unpaid undertaking. And so we'll see here further from the landmark case, Department of Interior against Klamath Water users. The Department of Interior had consulted local Native American tribes on assignment of water rights. Significantly, the tribes were among many applicants for water rights. And so there's an interest. You start to see the difference already with Wu, because those who evaluated this application, the experts, they were unpaid, they were volunteers, but they did not have a stake in that process. They are unlike the tribes here. The Supreme Court ruled that the tribes could not be considered consultants to the department. The court explained that an outsider cannot be a consultant when the outsider is seeking a government benefit at the expense of another party. And this is another consultant corollary case. And it's one that I thought that there would be some development on. So I checked and it has not been overturned. It's People for the American Way Foundation against U.S. Department of Education. The court held that exchanges between the U.S. Department of Education and the District of Columbia Mayor's Office related to a federally funded school voucher program in the district were not intra-agency documents because the mayor's office advocated on behalf of the interests of its own constituents. The court also found a lack of a consultant relationship between the agency and the mayor's office, shared responsibility for the DC voucher program, such that information was not being conveyed to the Department of Ed to unilaterally make ultimate decisions based on the DC mayor's advice. And so the wheels should be turning and going to Klamath, going to that one that we discussed, the case we discussed earlier, and going to Wu, because they, especially Wu, the experts providing their input, making a determination, whereas it's not a conveying from one to the other here. So we do not have that consultant relationship. The court noted that its holding was consistent with the fact that there was no precedent for withholding documents under Exemption 5, where a federal agency and a non-federal entity share ultimate decision-making authority with respect to a co-regulatory project. And so we are at redaction. I hope that I'm not moving too fast for folks to grasp what's been disseminated this afternoon. And so redaction covered by DC Official Code Section 2-534B. Any reasonably segregable portion of a public record must be provided to a requester after deletion or redaction of any exempt portion. A record may only be withheld in its entirety if the agency determines that the record cannot be reasonably redacted. And so if there are portions that are releasable, the entire document must not be withheld. It must be redacted and the releasable portion be given to the requester. A document may contain parts that are protected by a privilege and parts that are not protected. The existence of the privileged parts cannot be used to justify withholding the non-privileged portions if reasonable redaction is possible. The reasonably segregable requirement is a statutory obligation to consider individual portions of records for disclosure. This prevents the withholding of entire documents simply because an exemption applies to parts. And I know sometimes it's tedious going through all those records and searching and redacting, but that's the process. That's the correct way in making the determination and applying the redactions correctly, applying the exemptions to the relevant portions of the document. In each case, the justification for the deletion must be explained fully in writing. And so if you have redacted based on Exemption 2 and Exemption 1, you would not only state in the response letter about one exemption being applied, but you would state both. You would provide the portion of the document or describe the record that has been redacted under a certain exemption in your letter. And also let that redaction clearly shows what exemption is applied. And as we move along, I have a document that I will illustrate. So if it's exemption 1, when you redact, you place exemption 1 either in the redacted area, if you're unable to do so, as close as possible. And it's best to place it in that redacted area, especially if on that one document or that one page, there are several redactions. And so it will be clear to the requester. And so you would only not do this when making that indication would harm an interest protected by that exemption. And so as it is technically feasible, go ahead and do it as such so that the requesters do not have to question what exemptions are applied to which area and which ones correspond with the letter. How to perform reasonable redaction of records. And so as we look at this record, we know that it would be very unreasonable to say, okay, the portions to be redacted are these minute areas. And so it's inextricably bound. I can't segregate, I can't redact. No, we see that the portions here, they are clear, and the releasable portion of the document far exceeds, even though that's not the threshold, but we see that this can be reasonably redacted and released to the requester. And so this is a little document I've created here just with some information I know that will, and I'm going to demonstrate, and because I'm using PowerPoint, bear with me, it's not our regular redaction tool. So our first sentence here, Tom Jones' home address is 21 Mont-Sinage Road, Albuquerque, New Mexico. And so Tom Jones is a government employee. We don't have, based on this document, any information to want to withhold that government employee's name. But his home address is, exempt under exemption 2. And so we are going to go ahead. Let me use the highlighter, improvise. And if I can get to the black, that would be better. And so this will not be perfect, because we're using PowerPoint. And so you would obscure. This is not proper obscuring here, but it's just a rough example. And so on top of this redaction, you would put your exemption code. And so let us see if we can grab and put it in another color, red, so it's readily seen. And so this will not stay because of what I'm using, but you see, you would put your 2 there. And it's better to put it there in lieu of putting it somewhere in the margin, especially on a document when this one, you could put it because we're only going to redact maybe 2 other portions, but it's best to put it on top. So we go down here and we see that the booking information provided by Mary Jane, it needs to be updated. And we read along, and the only thing that we see here that needs redacting, because she's a government employee, her work telephone number is there, and so there's no need to redact that information, but we see that her personal telephone number is here as well, and so we would redact that information. And so we're not going to take out non-exempt information such as telephone number. No, we leave that in and we just take out the number, and then we go and we get our red here to make that designation. Get my pen. I'm improvising, bear with me. and then we would put our redaction code there. And so that's just an example. I hope in the future to be given the opportunity to do more of these redactions and find a better way of illustrating. And so let us move along here. Questions to ask when redacting. Am I withholding an entire record? And if you're withholding an entire record, then there's no need to redact. You're withholding in full. Next, are parts of the record not exempt, meaning releasable? So if there are portions that are not exempt, you're not going to withhold that document in full. You must redact the document accordingly and release to the requester, and your letter prepared in accordance with those exemptions, redaction, stating the document, the portion of the document describing the document that has been withheld, or the redacted portion. 3, have I redacted only the exempt parts, or have I incorporated some non-exempt releasable parts? And so some information may seem like, okay, we don't want the public, we don't want this to be seen by others. But if there is not an applicable exemption, that information is releasable. Answers to release or withhold questions. Did the search yield responsive records? If the search yields nothing, then you're not withholding a record and you're not required to release records. So this is an NIF, no information found. So that the letter must accord. So you're not releasing, you're not withholding, so you're not going to mention exemptions in your NIF. Is the requester receiving everything found without any redactions granted in full? If the requester received everything found in full without redactions, you're not withholding an entire record. You're also not withholding a part of the record. So you release the records with your granted in full letter. So don't create more work for yourself, because these are the easier or easiest letters, no information found, granted in full. And so answers to reasonable redaction questions. If you were to pick any random part of the record, would that basis be applicable? If yes, it is proper to withhold in its entirety. If no, you must redact and produce the record. Is the reason personal privacy? Does the entire record raise privacy concerns? Example, a tax return, or only parts? Example, a letter with someone's social security number. Redacting personally identifiable information may preserve privacy if the record contains non-exempt content. You must produce the non-exempt content to the requester, even if you redact some content. For example, to prevent a clearly unwarranted invasion of privacy. Answers to reasonable redaction questions. Are you withholding due to attorney-client privilege? Is all the document embraced by that privilege? So if all the document is not embraced by that privilege, and you look and no other exemption applies, then you have to redact and release accordingly. Also concerning attorney-client privilege was part of the communication shared with a third party. You're looking there now of privilege being broken. Is the reason deliberative process? Is the entire document part of the deliberation, or are parts of it? Are there definitive statements of already established policy? Because if there are definitive statements of already established policy, then there is no deliberative process privilege there. Does the document contain purely factual information, example, charts and graphs? If that's the case, there is no deliberative process privilege. And was the record shared with a third party? So let us take the charts and graphs. Purely a factual information. Using those charts and graphs to make certain decisions, and in that process, there are developments, there are discussions, but the charts and the graphs are, they're separate. There's nothing added to them in that process. And so if they're just those charts and graphs from before, they were not created in that process, then they are not deliberative. Let's say they are taken and they are, they're revised and there are certain information added, and that information is in the core of that decision-making process, then we would have a different consideration of them likely becoming a part of that deliberative process. Answers to reasonable redaction questions. Are you withholding due to commercial interest? Would the release of the entire document cause harm? And so if the release of the entire document would cause harm, it means that exemptions, you must look into applying those exemptions. And would only the release of the dollar amount cause harm? So if it's only the dollar amount that would cause harm, you go ahead, you redact your document under exemption 1 and you release. But the first scenario, you would withhold in full under exemption 1, and in withholding, as we discussed previously, there's no need to redact a document when you're withholding in full. You send your response letter describing the document being withheld and the exemption the document is withheld under. Question 3, reasonable redaction. If I remove the exempt portions, will there be remaining information? This case, Mead Data Center, the court states that non-exempt portions of a document must be disclosed unless they're inextricably intertwined with exempt portions. And remember our document earlier where there were only few parts that were redacted. That's certainly not an example of being inextricably intertwined. If you redacted all exempt portions, would you be looking at a wall of black ink? If so, then you do not have to engage in redaction. You withhold that document in full. Are there paragraphs or pages that would not be exempt? If so, then you redact, you release accordingly along with your response letter. How to treat non-responsive records. And we touched on a part of this earlier. Once I've identified a responsive record, can I redact information within the record that is non-responsive? And no, the answer is no, but I'll move ahead later on to some things that I've seen on the federal side. Once the government concludes that a particular record is responsive to a disclosure request, the sole basis on which it may withhold particular information within that record is if the information falls within one of the exemption, the FOIA exemptions. And the case on point here is American immigration lawyers. And what does this mean? That discrete information within a responsive record cannot be redacted based on non-responsiveness. It can be redacted only if a statutory exemption applies. So one may not want all eyes to be on that document, but based on FOIA, it must not be withheld. It must not be redacted if one of the exemptions do not apply. And so on the federal side, I've seen where a requester asked the agency's FOIA officer to redact the non-responsive portions of the document. if the responsive and non-responsive information were on the same pages, in which case the redaction code was NR, non-responsive. And if this is something that you engage in, make sure that you have that in writing, this agreement with the requester in writing. If it is a telephone conversation, put it in writing, have the requester confirm in writing, or vice versa. And reason for agreeing to this form of redaction is that it saves the agency time in that privileged and confidential information will not have to be redacted within the non-responsive portions of the document. So recapping here, the most frequently used DC FOIA exemptions, trade secrets, privacy, law enforcement, agency communication. We are counting 1, 2, 3, 4, respectively. And some reminders here that there are 2 criteria to be fulfilled under Exemption 4. The record must be interagency or interagency, and there must be an applicable litigation or civil discovery privilege, deliberative process, attorney work product, or attorney client. Reminders, there are 2 elements to be fulfilled under each privilege: deliberative process, pre-decisional, and deliberative. Attorney work product, prepared by or at the direction of an attorney in reasonable anticipation of litigation. Attorney client, confidential communication made with the intent that it remains private, and for legal purpose, communication for the purpose of seeking or providing legal advice. And so when you address your mind to, and I'm saying exemption 4 here, and so if you're, for whatever reason, addressing your mind going back to federal, it would be 5. And so when you think about agency communication, when you think about that exemption, always be ready to remind yourself about the different prongs, the different elements. And 2 is a bright line marker to be reminded. These are websites to useful information for your information: Reporters Committee for Freedom of the Press, U.S. Department of Justice, OIP, and Mayor's Office of Legal Counsel, MOLC. And upcoming trainings. So this one is the 3rd in the general series, but we'll also have the DC FOIA officers summer training series. There are 2 remaining in this series. The next one will be on the 11th of June, and Chief Counsel Neal will be facilitating that one. The last one will skip the summer series. That one will be presented by Director Allen, managing the FOIA process, September 10th. The summer series will run from July 9th to August 13th. And you will receive information in the next few days about this summer series. I will be presenting on July 9th. And tentatively, the August course will be preparing for FOIA litigation, tentatively to be facilitated by Assistant Attorney Generals at the Office of Attorney General. And it will be moderated, the question and answer segment, by Director Allen. The office's contact information is here. The general email address, opengovoffice@dc.gov, the telephone number, and members of staff with the contact information for each of us. Bega's FOIA officer, again, is Anthony J. Skirbo. Please feel free to reach out to any of us with your questions, and we will get back to you promptly. And so I'm at the juncture of taking questions. Again, thank you for attending this training. I will stop sharing. and check to see whether there are any questions.
There are no questions in the chat.
Okay. Thanks, Anthony. And so if you held your questions to verbalize at this time, you're most welcome. Please go ahead. You're all most welcome. I'll just stay on for a minute more, just in case there is something for me to address. Hearing and seeing none, thank you all again and have a great evening.